Doctrine of waiver. What is the meaning of doctrine of waiver? Waiver, you know very well, it is nothing but losing or sacrificing our rights, fundamental rights. So, doctrine of a waiver is a constitutional principle or constitutional interpretation. Whether we can waive our rights, that means we can deprive our rights, individual rights, or group rights, or public rights, or not. Yes, just like suicide. Once upon a time, suicide was a crime. Now it's not a crime. It's a human right. Right to live, in the same way, right to die also. A human right. It is being considered as. In the same way, here, we have been conferred upon the fundamental rights by the Constitution of India, Indian Constitution. But we can voluntarily deprive of our rights. How can we be deprived of the fundamental rights? Whether we can be deprived or not, because once the public, the citizens are conferred fundamental rights by the Constitution, it cannot be taken back. It is the constitutional philosophy. Everybody is expected to enjoy the right in our democratic setup. And the second one is nobody can resort to self discrimination or self incrimination, self conviction according to Article 20. And according to Article 21, everybody can enjoy the fundamental rights, right to life, right to dignity, etc. etc. A lot of things are there. So, whether a person, individual, or a group can be deprived of the fundamental right is the question. That is an exempted one. This doctrine says, okay, now if we study some two or three cases, then we can understand what is the waiver of these rights, what is this principle, constitutional principle. Let us take the first case, that is Bashishanath versus Income Tax Officer, 1959. In this case, what has happened is the petitioner sought the court of law unwansomely. The background of the story is the income tax officer elevator gave a notice to the petitioner to pay rupees 3 lakh for his concealment of amount and also at the same time the interest therein. And finally, anyway, however, the petitioner accepted the increment, accepted to pay that amount, total amount of 3 lakh, including the interest. Later on, in due course of time, before paying, he came to know that one Mr. M. or MC Muttaya, in the similar case, was could enjoy the privilege. He did not pay that because paying that kind of amount is quite contrary to Article 14 of the Indian Constitution. Having come to know about this case, he just made an appeal. He approached the court, and the court said, here the contention of the income tax authority is section 5 clause 1 of the taxation of income and investment commission. According to this section, he has to pay the tax for this concealment of amount, including the interest, this much figure. That is the contention. The second point is, the petitioner has accepted to pay that amount. He agreed. He gave the agreement also. Sir, in due course of time, I will pay, sir. Please give me some amount, some time like that. He made an appeal. We waited for that. So that is the contention. These are the 2 points in his contention. And the court said no. By mere acceptance to pay that amount, it doesn't mean that he is deprived of the fundamental rights of Article 14 of the Indian Constitution. So, no person can be deprived of the fundamental right conferred by the Constitution, he said. The court said. That is the first case. Whereas in the second case, the way I have mentioned this case is it is a celebrated one in 1955, 59. But actually speaking, the other cases, 2 cases, which are now I am going to say, by that you can understand very clearly. The second popular case is Volga-Tellis versus Bombay Municipal Corporation. So in this case, A very interesting thing is it is about the payment dwellers. The pavement dwellers, they temporarily constructed huts on the pavement belonging to Bombay Municipal Corporation. And the Bombay Municipal Corporation asked them to vacate in due course of time whenever they want to construct the public road in that area, in that location. And the pavement dwellers gave the what is that undertaking. Okay, in due course of time, whenever you want to construct that road, public road, definitely we will be vacating. So let's have some time. So that undertaking was issued, supplied, served to the municipal corporation. And the municipal corporation, in due course of time, and means after some time, whenever when they got funds for the construction of the road, public road, they asked them to vacate. And now they are aware of the fundamental rights and all that, the payments, the public, they are aware of it, and they made an appeal. They filed a petition in the court of law. There, the court observed. So your action, these see that the municipal corporation's contention is they have given the undertaking. Whenever we need that land, that place, the huts will be, they will vacate the huts, and we will be demolishing the huts, and we want to construct some road, public road, etc., or some other purpose, for some other purpose we will be doing. So they have given the agreement, they have given the undertaking. They said that is their contention. Whereas the court said, no, it is not correct. Though they gave the undertaking in the dire need, it doesn't mean they may be, they may have given, of course, but it doesn't mean that they are deprived of the fundamental rights under Article 21. 21 covers not only livelihood but also a residence. So your rash decision of vacating them immediately, you see, when it belongs to your land, your area, the property of the municipal corporation, you may ask them to vacate, but not very immediately, because they should not be deprived of livelihood and also residence. And the second one is you must give a reasonable time for them to vacate. So this is the contention of the Supreme Court, and finally said no. You give them suitable time, reasonable time, and also at the same time make arrangements, alternative accommodation after giving some time for them. Then only you have to ask them to vacate. They should not be deprived of it. And here, one important remark made by the court is, see, no individual or public or some group of people can deprive of their barter. Barter, that is the word that is used. They cannot barter the fundamental rights for some other benefit also, for their temporary benefit in the payment. For that purpose, they can't deprive their fundamental rights. That's what the Supreme Court said. And another important case is Narsingh Paul versus Union of India, 2000. Here, the case is about one telecom labor. This telecom labor worked in the telecom department for more than 10 years. At that time, he was entangled in some criminal case. And moreover, when he was being tortured by the department because of this criminal case, and this criminal case was, he was free from the criminal justice because he was acquitted in that case. Even then, he was removed from service. Retrenchment benefit was given to him, and he was sent out. He approached the court of law. His contention, the contention of the department is, he was entangled in the criminal case. He was not in accordance, his behavior, everything was not in accordance with our rules. So we have taken our decision, retrenchment decision. We have that right, and we give that amount also to him. Retrenchment benefit. Once he was removed from the service, out of retrenchment, industrial law, as per industrial law, they have the right whenever excess employees or the shortage of fuel or some other reasons, retrenchment decision they can take. So during that course of retrenchment, he was given some benefit also and removed from service. That is the contention of the department, telecom department. But the contention of the court, the decision of the court is this. Okay, he might have been entangled in the criminal case, but he was acquitted. One thing. Number two, according to Article 311 of the Indian Constitution, employee or labor, even labor, he was a casual labor actually speaking. Even then, that benefit, the provision enshrined in Article 311 of the Indian Constitution is extended to employees and also the labor. And Article 21 is protection of human right was also violated. So retrenchment benefit, it doesn't mean that he is deprived of the fundamental right. By giving a retrenchment benefit, you can't say that my work is over and all that. His rights, he should not be, regarding his rights, he should not be deprived of it. So whether it voluntarily or by force or by whatever it is, one, that means no individual can barter or can be deprived of the fundamental rights. And if at all he wants to, the long and short of the matter is this: if at all any individual wants to deprive himself of his fundamental right, it should not be at the cost of the public, and it should not have any negative impact on the public at large. That is to be noted. This is about the doctrine of waiver in brief. Thank you very much.